Welcome to Cyber Mayor of Yuma. And on this page, What's New at City Hall, we will be continuing in the clown's investigation of the mayor. Now, we've already seen in parts 1 and part 2 that in order to have the question of investigating the mayor placed on the agenda of the regular council meeting of February 1st, that the clowns violated Robert's Rules of Order, City Code, City Charter, and the State Open Meeting Law. Yet, the culpable clowns only consider it to be an offense when it's being charged against others. Now, for those that have emailed this website and stated that I was being intentionally disingenuous for failing to address the most serious of the charges, that of conflict of interest, not to worry. I've purposely reserved that issue for the last. Now, recall that from the very beginning, I've stated that I'm not defending the mayor, but rather it's my intention to continue to shine a light on the duplicitous double standards of the clowns. Now, in part 3, we will see that engaging in conflicts of interest is not a foreign act among the mayor's fault finders. Indeed, another smoking gun. But first, let's finish the regular council meeting of February 1st. Now, after all of the injudicious gyrations to resurrect Stewart's failed motion of January the 18th, the clowns finally had their shot at voting to investigate the mayor and to hire a law firm to validate their foreordained suppositions. So now the investigation is underway and it's relatively quiet until the investigation is completed and the report is ready to be presented to the council at a special call meeting to be held on Monday, May the 14th. Now, as with the special call meeting of January the 25th, the clowns again repeat their violations of the city code. Witnesseth, as can be seen by the affidavit posted here on this page, the city clerk once more filled the role of both the affiant and the taker of the affidavit, both the filer and the filee. Now, moreover, when a public record request was submitted to the clerk's office inquiring as to whom on the council called for the special meeting of May 14th, it was the standard carte du jour expected from One City Plaza. There are no further records to fill this request. Now, folks, the city code posted here on this page is clear in that special meetings can only be called by the mayor or a majority of the council. Yet the city clerk, attesting in a sworn affidavit that the special meeting was noticed in accordance with the Yuma City Code, cannot or will not disclose the caller of the meeting. Where's Truth and Transparency Thomas when you need him? Now, to give the flavor of the objectivity of the independent Penarts, a number of gems were offered throughout the report during his presentation. Such gems as it is special counsel's opinion, the special counsel finds, appear to corroborate, appear to be professional, and to be telling things as they are, providing the most credible version of the events. It is reasonably certain in the legal judgment of special counsel, and special legal counsel believes, and on ad nauseum. Now, in the end, in each instance, while Penard strained to the fullest to create the impression of credibility for his suppositions, his failure to produce bona fide evidence consigns his opinions to the realm of unsubstantiated guesswork, or in layman's terms, he said, she said. Now, the guesswork and the he said, she said was present in the individual accusations of conflict of interest as well. Now recall that in Part 2 it was stated that a molehill can take on mountainous proportions when the gang at One City Plaza resolves to trash the character of others. Now, that tactic was employed by Penarts in the alleged warehouse conflict of interest, and translation for that is create a means to obtain the desired end. Now, a quick side note. For $75,000, one would think that the good folks of Yuma could expect something that at least resembled a quality product. Yet, throughout this entire section, Penarts refers to former city administrator Mark Watson as Mark Watkins. But hey, he's already got his paycheck. Now, for those that may not have followed the city council campaigns in 2009, a good deal of dissatisfaction had been voiced concerning upper management at One City Plaza. And at that time, then candidate Krieger agreed and pledged to make the sought-after changes if elected. So, after becoming Mayor Krieger, in less than 90 days from taking office, the occupants of the two highest positions in the city organization vacated their post. Now, unfortunately for the mayor, if fulfilling your campaign promises involves upsetting the status quo, you can take it to the bank that as sure as the sun rises in the east, retribution will follow. So, Penarts' star witness in the warehouse issue was none other than the former city administrator whom Penarts stated special legal counsel accepts Mr. Watkins' interview statements as providing the most credible version of the events. Again, please note, it's Watson, not Watkins. Well then, what were the events? And what were Mr. Watson's statements? Well, the mayor and the administrator were windshielding possible properties for the city's enclosed storage that they had need of. And in driving by the mayor's warehouses, the administrator stated that he, the mayor, could not be involved in the sale of the warehouses to the city because he had a conflict. That can be seen on page 22 of the report. Now, that would be true if the city had expressed any interest whatsoever. Then indeed, at that point, the mayor would have been in a declarable conflict of interest position. Now, according to a published guideline from the Office of the Attorney General, the mayor would then be required to declare a conflict of interest prior to the matter being addressed by the city council. Now, Penarts' assertion, however, that it is an immediate conflict of interest for the mayor or any other elected official to so much as make it known that they have a property that may meet a city need is purposely misleading. There was no interest on the part of the city, and moreover, to his credit, the former administrator's statement that Penarts tells us provided the most credible version of the events, again on page 22 of the report, was that the mayor did not pressure him to make a deal. End of discussion. So, given the Attorney General's guidelines and Penarts' own account, the mayor was within those parameters. Clearly, Penarts was attempting to earn his $75,000 by making a mountain out of a molehill. Now, in the Avenue 3.5E conflict, Penarts was making Mount Everest out of an anthill, and his wily, underhanded tactics were on full display. Now, following 9/11, discussions began about a possible proposed loop around the MCAS frontage along Avenue 3E, and the mayor's family owns property in the general vicinity. Now, in 2007, when the issue was brought before the council, then Councilman Krieger declared a conflict of interest. And the issue was again considered at the council meeting of June 4th, 2008, when Krieger was out of office. Now, at that meeting, Citizen Krieger stated that he was not opposed to the motion. And that can be seen here, posted on this page. Penarch then jumps to 2010, smugly informing us that at the council meeting of August 17, 2010, the now Mayor Krieger did not disclose his conflict of interest in the issue. Come on, Penarch. For $75,000 of the good folks' hard-earned money, surely you can do better than that. Now first, Penarch conveniently overlooked 2009. Now Krieger is still not in office, when ordinance number 2007-35 had been amended by ordinance 2009-33, wherein the Krieger family property was now excluded. Wherein the Krieger family property was now excluded from the proposed project. Now, moreover, Penarch erroneously or intentionally disingenuously identified the meeting of August 17th as a council meeting, and that infers a regular meeting where both discussion and possible action may take place. Now, the meeting of the 17th was a council work session, and the agenda item, Avenue 3.5E design, was for staff presentation only. It was not a forum where Mayor Krieger could argue and attempt to influence the council's vote. There was no vote to be taken, and further, it was not on the agenda of the regular council meeting the following day on the 18th as an action item, nor was it scheduled to be on a future agenda. Translation, with official action having been taken that excluded the mayor's family property from consideration for future acquisition, and at a forum where no action can be taken or is anticipated to be taken in the near future, Penarch tells us that as the mayor of the city of Yuma, representing the interest of the good folks that elected him to office, Krieger cannot express his judgment that the project is not necessary to the well-being of city residents. Why not? Well, because that would not fit the independent Penarch's misrepresentation of events. Now, a side note. While Penarch whined that the mayor argued against the need for the project, he slyly omitted telling us that I'm the Deputy Mayor Johnson, the mayor's arch nemesis, expressed concerns that this was a case of overbuilding streets in areas where they're not needed. Councilmember McClendon voiced her reluctance to revisit the issue, and Councilman Mendoza was adamant that the issue can wait another 10 years. That can be seen in the minutes of the council work session of August 17, 2010. And then finally, Penarch poo-pooed Mayor Krieger's suggestion that if indeed he was stepping into an area of likely conflict of interest, the city attorney could have addressed the question. Now, according to Penarch, it is not the city staff's responsibility to keep track of elected officials' personal business interests in order to keep them from running afoul of conflict of interest issues. Fair enough. However, as can be seen in the minutes of the council meeting of June 4th, 2008, that are posted above on this page, in response to a question from then private citizen Krieger as to how his family's property would be affected, the dutiful city attorney, Stephen Moore, stated that he would research the issue and provide an answer to both the council and Krieger. So, Mr. Penarch, there you have it. Moore had full knowledge of the mayor's situation, and the city charter clearly states that the city attorney shall, not maybe, not perhaps, not if you feel like it, not if you get around to it, the city attorney shall serve as the chief legal advisor to the council, and yet the city attorney said nothing. Nonetheless, for 4 years, each and every time the Housing Authority of Yuma was on the council agenda, Moore can be seen arising from his seat, walking behind the dais to advise Councilman Mendoza to declare a conflict of interest. Clearly, the city attorney is most selective in imparting his conflict of interest advice. Now, the incontestable conclusion: it is not possible to have a conflict of interest if the city has already taken official action to change its proposed project to exclude your property from acquisition. Now, in what Penart's titles in his report as conflicts of interest, business relationship with Eckert Construction, Penart's overreach to connect the dots is a real stretch, because there are no dots. Now, if the item of business had been the awarding of a city contract to Eckert, then as an employee of the company, indeed, the mayor would have had to declare a conflict. However, the discussion and the action related to general policy only, and there was absolutely nothing specific to Eckert. To the contrary, Eckert was one among any number of contractors that might be affected. Specifically, according to the law, Eckert was part of a class of people whose interest was no greater than other members of the class. It's called the Rule of 10, Penart's, but nice try anyway. Now, a side note: a current council member is an employee of a local company that has conducted business with the city in the past and may well conduct business with the city in the future. Yet, this council person was advised that because of their relationship with the company, being simply that of an employee, they were not required to declare and file a conflict of interest. Why is it then that Penart's rants that the mayor, simply an employee of the company, failed to file a conflict of interest? Can anyone say double standard? How about hypocrisy? Now, one final conflict of interest leveled against the mayor, according to Penart's, was the mayor's involvement at the regular council meeting of January 18th. Now, Penart's informs us that because the mayor receives a salary, he had a pecuniary interest in the council's actions to investigate him, and he should have declared a conflict and made known his specific conflict on the public record, the minutes of the meeting, and filed a notice of the conflict with the office of the city clerk. Well, first, if Mr. Penart's would familiarize himself with the statutes, he'll find that they give the option of either or, and they do not require both the making known of a specific conflict on the public record, the minutes of the meeting, and the filing of a notice of the conflict with the office of the city clerk. The accepted practice within the city of Yuma for elected officials is to file a copy of the minutes of the meeting in the disclosure file that is held in the office of the city clerk. Now, I don't suppose Penart's would consider some sort of a refund of part of the taxpayer's $75,000 for having to take him to school. No, probably not. Now, additionally, the mayor's pecuniary interest was not in jeopardy, because Penart's himself tells us on page 32 of his totally impartial investigative report that the city council does not have the authority to remove the mayor. Thus, the council has no power or control over what Penart's calls the mayor's pecuniary interest. Now, moreover, when challenged by Point of Order Johnson as to his participation in the meeting, the mayor deferred to the city attorney, and he was told by the city attorney that he could respond to the allegations being made against him. No, the mayor was not violating the conflict of interest statutes. He was simply defending himself against the raw, naked assault of the clowns. Translation: the clowns were out for a Wild West-style lynching, and they're whining because the mayor would not placidly comply by placing the noose around his own neck. Now, to further establish the double standard of One City Plaza, follow what happens when the fickle finger of fate points towards one of their own. You can bet that the response is going to be that of a towering mountain becoming nothing more than a diminutive molehill. And that would bring us to Stephen W. Moore, Yuma City Attorney. Another smoking gun. Stephen Moore began with the city of Yuma more than 30 years ago as an assistant city attorney. And at one point, after becoming the city attorney, he quit and went into private practice. And then, in 1991, he closed his private practice and returned to his position as city attorney. Now, at that time, Moore filed with the office of the city clerk a disclosure memorandum enumerating a number of private client cases in the event that a conflict of interest may arise with the city. And also, at the same time, he included in that report his position as an officer and director of an Arizona corporation based here in Yuma. And that can be seen posted here on this page. Now, from time to time, over the years, that company had business that would come before the city. Now, according to Penart's, Moore is required to file a conflict of interest on each occasion. Yet the only notice of his position with the company is the memorandum that was quietly filed away more than 20 years ago. And he has never, as required per Penart's, declared a conflict and made known his specific conflict on the record, the minutes of the meeting. Where's Penart's when you need him? Now let's take a look at one of those specific conflicts. At the regular council meeting of April 3rd, 2002, the council voted to approve ordinance number 2002-26. Now that ordinance was for the purpose of purchasing property for street and intersection widening. Now as it happened, the company for which Moore is an officer and a director owned 2 commercial lots that were included in the ordinance and were subsequently purchased by the city for multiple hundreds of thousands of dollars. Now, the minutes of the meeting posted here on this page clearly show that Moore was present and that the ordinance was adopted without discussion and most certainly without an open declaration of conflict by Moore. Now further, as can be seen from the ordinance itself, posted here on this page, the document was drafted by the city's legal department, of which Moore is the head. And most indicting, the ordinance bears Moore's approving signature. Now folks, the end result of the conflicts of interest alleged against the mayor by the clowns is that absolutely nothing of any value or benefit accrued to his account. Moore's conflict, however, resulted in him, as the city attorney, approving the form of the document that directed the dispersing officer of the city to pay multiple thousands of dollars to the company of which he serves as treasurer. So, while Moore is enjoying a free pass, how can serious consideration be given to purely prejudicial political assertions against the mayor? Now, it's also clear that by filing the disclosure more than 20 years ago, Moore himself understood and acknowledged that future conflicts were possible, if not probable. Now, perhaps Penart's would like to amend his report to the Attorney General. Probably not. Now, there are other examples, such as in 2009 when the company requested the council's approval of a liquor license application absent Moore's declaration of conflict, but you get the idea. Now, at this point, a special note. It needs to be clearly understood that by exposing Moore and the council's double standard antics, there is absolutely no negative inference whatsoever being made toward the company. The company is a long-standing, solid contributor to the betterment of our community, and for that reason, their name is being withheld. The culpability for failing to file a conflict of interest is Moore's alone. So, there you have it, folks. The clowns and their sycophants, to borrow a favorite expression from Point of Order Johnson, have violated literally every thrust that they've charged against the mayor. Now here's a novel thought. If the clowns were genuinely concerned about disclosure, they would be openly examining all of the breaches of the agreement between the city and their wheeler-dealer California developer. Now that's the real issue. Yet the council has been voiceless since their gym on the Colorado, the hotel and conference center, went into foreclosure back in August of 2011. Now that's going to be our next focus here on Cyber Mayor. So tune in to the Riverfront Hotel page on this website where you'll be able to see where literally millions of taxpayer dollars are flowing to other than where they were intended. I love this job.